to all the listeners. This is Attorney Sharp Raleigh for the Sharp Raleigh Law Show, and today we're going to, of course, discuss about immigration law and also debt settlement. And I have Michael on the board with me. And just before I start, anything I'm telling you today is my opinion. You should not act or refrain to act solely on the information provided. You should contact an attorney if you have any questions. And we're live today, and it's October 4th, the first show of the month, and we're going to discuss about few topics and then take the calls. The number to the studio is 510-657-1170, 510-657-1170, and the number to our office, 510-742-5887, the website attorneyonair.com. So I just wanted to now cover two topics, very important topics. One, I just did a video on that on our YouTube channel, youtube.com/SharpRaleighLaw, and I spoke about the cap gap issue that we are facing now. As you know, a lot of people benefited from cap gap because their H1B got picked up. I'm talking about the new H1B. The cap gap is what allows F1 students to continue working even their OPT expired if it was after the OPT was valid after April 1st and it got terminated before September 30th. So you have the cap gap up to September 30th. So USCIS issued a memo, not a memo, but an announcement telling people that for those who didn't get their H1B approved yet or any answer on their H1B, they have to stop working. However, you can continue staying in the country, but you cannot work, which is a big problem because most of those people, what are they going to do? Just sit at home, and then they might even lose their job, and the job which actually is petitioning for them. So it is really a very, very tricky situation, especially now there's no premium. That means you cannot premium the case to get an answer. So what it does, it creates a real uncertainty on the students, especially those who have the H1B picked up. So there are many people have suggested moving to CPT, etc. These are not good options, by the way, although they are available, especially if you're going to take the multiple same level of education CPTs or day one CPT. So be very careful if you're trying that, because we are seeing RFEs on those, and we probably will see denials coming soon based on those. So it is not a good idea. One option that has been I was thinking about, and it seems like the American Immigration Lawyers Association is also kind of not advocating for it, but telling about it, is the Writ of Mandamus. And also I had a video yesterday about this on the channel. And the Writ of Mandamus is basically a writ. That means a something that is filed with the federal court. It's not with the immigration court, by the way, federal court, forcing the administrative agency to make a decision on your case. I repeat that, forcing the administrative agency to make a decision. A decision doesn't mean it's a good decision. It just means a decision. The way it works, you have to show that you have exhausted all your administrative remedies. That means you have tried everything and it's not working. Then you sue the government under the Writ of Mandamus to push for the H1B. The problem with that, there are a few problems. Number one, many lawyers don't practice in federal court, so they are not there. It's hard for them to go there. I've done a lot of Writ of Mandamus back in the days when after September 11, we're talking about around 2004, 2005, I think, where I was filing a lot of them because a lot of cases were getting stuck. And most of the time, I would say, I think practically in 99% cases, I think, unless I'm mistaken, we got an approval. Now the issue is, what are the risks? Okay, Michael, I'll take the caller in 1 minute. Let me just finish those two topics, then I will take the caller. So basically what it does, it actually talk about, there is a risk. The risk is basically Once you do that, then they will be digging into your case more profoundly. That means any small mistakes can be used against you to create a denial. So be very careful on that. And also the fact that it is filed in federal court, you need a lawyer who's admitted in that court. I've been admitted in all the 3 California courts. Unfortunately, I'm not taking any writ of mandamus right now because we're too busy with other work, but it is costly. So a lot of people. And then fourth, also, it can be filed only by the company because the company owns the H1B. So this is where we stand for cap gap. A lot of people are calling me asking the question, what do I do next? And but these are the options. There are not many options, unfortunately. So we are kind of stuck. We are hoping USCIS will bring back premium for a situation like those. And let's see how things are going to unfold in the next few weeks. But we cannot expect too much from that, unfortunately. Let me take one caller, Michael, and then we'll move to the next topic. This is Shapra. You're live on air. Enough? Hello?
Hello.
Hello. Hi, Abhinav.
Hello. Hi, Mr. Shah. I had a question for you regarding the H1B visa.
Yes.
I moved my employer a few months back from employer 1 to employer 2, and I have my H1B stamp my passport with an old employer, but the petition with the new employer is valid till 2021. I wanted to ask, like, can I leave outside the U.S. and come back without the need of stamping? My old stamp is valid till 2019 next year.
Yes, you can use it. As long as it's valid, you can use it. Even if it's valid for 1 day, you can use it. There's no need to shift the stamp unless the stamp has been canceled or withdrawn or revoked by the State Department or something like that. You can use the same stamp and just attach the 797 with it, and you can travel. But just make sure you come before 2019. Okay?
Right. I see.
Okay.
Thank you so much, sir. Thank you. Have a good day.
You. So I don't know if I have more callers, Michael, but if not, then I'll move to the next topic, which is something very, very interesting. Yes, so we will open the lines, by the way, 510-657-1170, 510-657-1170. This is Attorney Shaprari. We're live on air today. We are on KLOK 1170, Radio Zindagi, and we are discussing about immigration law. The first part, we discuss about the cap gap issue, the option of the writ of mandamus filed in federal court. And if you want to know a little bit more about writ of mandamus, you can check my website. Just to let you know, I filed a lot of those back in the days. Now, recently I've not filed many, but it was one of the only tools we had after September 11 to actually kind of give a chance to people, unfortunately. And it did work because most of the time they end up by settling with us and granting the case. So it is an option out there, so check onto it. Now, the next thing that I wanted to discuss, and which is also kind of a lot of worry that people are getting, is about the RFE, no RFE, and no NOID cases. So there was a meeting between a group of, usually we as members of the AILA, we usually submit questions about what's going on, and they try to, through their liaison, they try to actually kind of answer us, and many times lawyers will ask questions, and many were asking, how is it going to work under no RFE situation, the rule of after September 11. As you know, there was a memo that was passed that they will not actually issue RFEs or NOIDs and just deny the cases. So the problem with that is it is going to be creating it's creating already a lot of tension. So they try to answer some of the questions. I'll cover that in a minute, but let me take one caller. This is Shaprari. You're live on air. Hello.
Hi, Mr. Shaprari.
Hello.
I have a question. So my wife is on H1B and she wants to start an IT consulting company, like a IT training company. If the H4EAD goes away, what would happen to the LLC?
I can't hear you. You get cut off. You say she's with an IT company and she's an H4EAD, right?
Yes.
Okay. And you're worried about the H4EAD being taken away? Hello?
Hello?
Yes. I didn't hear your question.
The voice is breaking. Let me call again. Sorry about that.
Okay.
The voice
Go
is
ahead.
breaking.
No, sorry for that. I apologize for that. You know, when we do live shows, we always have issues with technical issues, so I apologize for that. So until that person calls back, we're going to talk a little bit about the issue of the RFE and the NOID. So responding to inquiries from many lawyers of the American Immigration Lawyers Association, which we are a member too, they try to kind of clear a little bit a lot of those questions that people have, but still I don't think they kind of were very, very clear, even though they tried. So one of the things that we're seeing is that they're saying, for example, that you have they're not just going to issue avoid NOIDs and RFEs just like that. Their argument is that, this is going to be, we're going to deny cases if the case was improperly filed or there's a big deficiency in it. I'm just kind of trying to put it in my own words here, what they have answered. So basically, for example, if someone filed just a skeleton of the case and they didn't file all the supplement documents, they will not issue an RFE, they'll just deny it. But they say if there are some mistakes or misunderstanding, they will take their discretion. Based on their discretion, they will issue RFEs and NOIDs. The problem is that I'll discuss about the problem. Let me take one caller because this doesn't really work well. Let me take a caller. This is Shabra, 11 here. Hello? Hello?
Hello?
Hello? Yes, sir. Can you hear me?
No, I'm not able to hear properly.
Oh. Can you hear me now? Hello?
Little bit better, but let me ask my question and I will take the answer offline.
Okay.
My question is, I recently changed my job and I got an extension based on my previous company's I-140. And now with this new employer, let us say I do not have the I-140 initiated, and after 3 years when the H1B expires, can I get an extension with this company with my previous I-140 itself? I'll take the answer offline. Thanks.
Okay, perfect. Okay, that's a very, very good question. Can someone use the I-140 from company A and use it to get an extension with company B later on? The answer is yes. The rule just requires an I-140 to be approved. I hope you can hear me, Ajay. So the rule just requires an I-140 to be approved, and it can be from company A, B, C, D. However, the problem becomes if the dates become current. So if the dates become current, then since you will not be able to file a green card because you left the company probably unless you go back to them, then they might not grant you your H1B extension, stating that you should file for a green card. But apart from that, no, you can use the I-140 from company A, get maybe 2-3 extensions with company B, as long as company A has not withdrawn the I-140, which they cannot do after 6 months technically, or USCIS has not revoked the I-140. So as long as you have that, you should be fine. So let me take another caller. This is Shaparali. Hello? Hello? Can you hear me? Hello?
Yes, I can hear you. Can you hear me, Mr. Shah?
Yeah, definitely. Very clear.
Sure.
Go ahead, Raj.
So the question I had was, I am on I-140, and my wife is an H4 EAD. She wants to start an IT training company, and my question is that if H4 EAD goes away, what will happen to the LLC which we form?
Okay, first of all, this is one of the biggest worry of people. First of all, when you incorporate a company, the company becomes like a human being almost. It can sue, it can get sued, it can pretty much contract, etc. However, if the H4 goes away, then, the H4 is not going away, the EAD goes away and she no longer has an EAD card, it will be hard for her to manage the company. But the company will still stay alive. So if someone else takes over, she can still be a shareholder, but she has to be passive. She cannot work in it. She cannot do any kind of executive work, etc., etc. She can just basically take the dividend in terms of, there's no shares in that because this is an LLC, so it's members. So she can take her money as a member, but she cannot really do any active work like sign on checks, negotiating contracts, etc., etc. Ultimately, that's the biggest problem because on H4 EAD, you had the leeway to open a business. Now, on any other visa, you don't have that kind of leeway unless you go into programs like EB5, etc. But yes, the company stays alive and it's not affected. It's her who's affected. That means she cannot work there. That's all.
Okay, so we can transfer the ownership of the company if you want, but she will not be able to work in the company.
No, she can still own the whole company.
But she's not able to work. Okay.
Work in it, yeah.
And based on the current updates, what's the status of H4 EAD? Is it for sure that it will go away? What do you think?
Well, there's nothing for sure anymore, but there is a big chance it will go away. The question is, how will it go away? Will they allow people to continue using what they have or even one extension before taking it away, or they will just stop everything right away? And it is more likely that they will allow people, for example, let's say you have a 2021 EAD, you should be able to use that EAD till 2021. And this is what we are thinking based on the same courtesy they gave to DACA. But there's no guarantee at all because the H4 EAD is being highly targeted by groups like Safe Job, USCIS, etc., and they are really pressuring for that. And that's why the Trump administration came out with this announcement saying that, in 3 months we'll have a good language, we won't do public comments, etc., we'll just take it away. So we'll have to wait and see how they're going to apply that, and I'm hoping that there will be enough lawsuit against it that you ultimately will be able to keep it for a while. Okay?
Sure, thank you so much.
Good luck to you. I don't know if you have more callers, Michael, but let me talk a little bit again about this situation we're having now on the RFEs and no notice of intent to deny. And I was talking about these comments that came from AILA, and people are really worried because if their case is not filed properly, they will just get a denial, no RFE. And this is what USCIS was responding when asked the question. They say, we don't want to be mean. The whole idea is basically to protect any kind of fraud, frivolous filing, or skeleton filing, as we call it. That means just file the basics and the evidence comes later, which is not really, which doesn't really make sense to me, honestly, because the truth is that even you provide everything, you're still getting RFEs. And when you submit the RFE, you pretty much send the same thing, and guess what? And plus, how do we know USCIS is looking at something? So the whole idea is very, very vague and doesn't really hold water. But unfortunately, that's the argument they made, that first they say they won't issue RFEs for everybody. It's at their discretion. And for those who are for just simple mistakes or things that can be fixed, nothing was done frivolously, they will go ahead and allow an RFE to get the document. However, they're saying if your case is filed frivolously, then they might basically not issue an RFE and just deny it, and that's really not clear to me, But let's wait and see. Let's see how things are unfolding. We will get a feedback about the denials, etc. soon. Let me take another call, and then I'll continue. Hello, this is Shah.
Hello?
Yes, sir. I'm listening to you, Amir. Hello? Can you hear me?
Hello?
Hello? Can you hear me? Hello? I think we're having some technical problems today. I apologize for that. And unfortunately, depending where you're calling, sometimes because this is mostly done to a system that we are on the phone booth, so it kind of leaves not a lot of room for kind of having a clear conversation, and I apologize for that. So please call again. The number to the studio, 510-657-1170, 510-657-1170, and this is Attorney Sharper Ali from the Sharper Ali Law Group, and we are talking about immigration issues, and of course the topic of today is the cap gap issue, which I was talking earlier about the Writ of Mandamus, and now I'm talking about the RFEs and NOIDs, where there was a meeting by a bunch of lawyers from the American Immigration Lawyers Association. It's not really a meeting; it's a question and answers for stakeholders that AILA hosts all the time. We send our questions, and they try to ask them, and they answer us. So what they're saying when it comes to the RFE, they say not everybody is going to get it. Some are just going to get denials. However, they also say that they're just not going to deny cases on minor mistakes, etc. The problem is, and they also mention that you cannot just file a case on a skeleton. You need to provide all the supplement evidence. But this is where I have a problem, because even if you put everything out there, you still can get a lot of an RFE from them. So what happens in those cases where they don't issue the RFE and they're asking same questions according to them, and they use the discretion to deny the case? So it is not really kind of clear to me, although they try their best to clear it. And they keep repeating the fact that we are not going to try to be quote unquote mean, but at the end of the day, the whole system right now is being kind of mean, unfortunately. So, ladies and gentlemen, this is Attorney Sharper Ali, and you are listening to the Sharper Ali Law Show. Our show runs from 10 a.m. to 11 a.m., and on Fridays, midnight to 1 a.m. It's a repeated show. And we are talking, of course, about those two big issues where people are getting worried and they don't know what is next. I have people who've been here for years and years now suddenly feel so uncertain that they want to go back, or what they should do. Well, the first thing is that number one rule: as much as your friends and people want to help you or trying to give you legal advice, you have to take it with a grain of salt, because unless you practice in that field, it's really tough to give advice to people. Even I, who have been doing that for years, sometimes I don't know the answers, and it is becoming more and more common like that. But at the end of the day, you need to rely on a lawyer to give you an answer, and just listening to people might not do the trick. Although they might find some solutions for you, but they are not really in a position to kind of get the cases done, unfortunately. So we are right now. I think we have one caller, right? Let me take the caller and then we'll continue. This is Sharper. You're live in here. Hello. Hello. Hello.
Hello?
Yes, sir. Can you hear me?
Yeah, I can hear you. Can you hear me?
Yes, very clear. Go ahead.
Okay, hi. Yeah, so I have a question about EB1C category. So I'm in the EB1C, and it got retrogressed in April, but after October 1st, is it like got back? And I still don't see the current for filing action part. So I had a question about that. So I'm just waiting for AOS pending.
Oh, you're waiting. Okay. So it's not current right now. It's 2016 for processing time and 2017 for acceptance time. But it's not that far. It's like 1 or 2 years behind. So it's not like before it went to 2012. Now it's back to 2016 and 17. So it's another probably 6 months to 1 year. Hello? Okay. So this is another thing on the visa bulletin. As you know, I was discussing about that, I think, last week, basically stating that this time the USCIS picked the submission time. That means basically they are submitting where you can pretty much submit your documents, get the EAD, etc. So they are using the second chart, which brings most of the things very, very close to current for many cases. So it's important you know that. And then now going back to the situation we are having with the H1B and the cap gap, I covered that, and I think I didn't miss anything. I might have, so bear with me a little bit. And today, again, ladies and gentlemen, we are live on air, and it's October 4th, 2018. If you're hearing the show another day, that means a repeated show. And I also wanted to mention that we are seeing a lot of things happening on immigration, and I know it's already causing a lot of stress, and very much many people have started actually kind of looking for alternatives, right? And alternatives are, for example, some people are looking into EB1A, which is a very interesting one, because once you file that, you don't need, if you qualify, you don't need an employer, so we can get you a straight green card. And since EB1A for India is retrogressed just slightly, you might be able to get a green card within 1 year if you qualify. So that's another thing. And the other option that people ask me all the time is the problem of, do you have more callers, Michael? Okay. So one of the questions that I get very frequently is the fact that people will ask me to give an estimate on the visa bulletin. Where do we see things going? Well, at this point in time, it jumped a lot for many, but at the same time, you have to remember that we can see a retrogression anytime. I don't see a retrogression actually coming, but there might be one. So you need to be ready for that mentally, because that's where people get really upset. So I was talking about all those issues that we are seeing right now. And USCIS gave this background kind of, it's not a memo, by the way, it's a discussion between a group of lawyers and USCIS, which we basically use on a frequent basis. And this is where the information I'm giving you is coming from. So I think we have one caller, right, Michael? This is Shah. You're live in here. Hello? Hey, Sai. Hello? 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 Okay. So I think we lost the caller too. And again, I apologize today. We're having some technical difficulties. I don't know if it is from here or from somewhere else. So bear with us, please. I was talking, of course, about all those situations. It seems like every week we're coming with bad news. But the good news is that the alternatives are, number one, I would recommend checking to Canada, because that is easier for most people, especially for kids to adapt. Number two, if you are in a situation where your case is just denied, you can, if you are still in status, you can still refile and continue. If you're out of status, not out of status, but if you're out on the situation. So I'm kind of going all over the place today because there's so many things to discuss. But I was talking a little bit about some of the options for people who are basically are stuck on not getting an approval, etc., etc. And I will also recommend to people looking to EB1A or national interest waiver. It might be a good option for people. So again, ladies and gentlemen, this is Attorney Sharp Raleigh for the Sharp Raleigh Law Show, and today, unfortunately, we are having some cross lines, so some of the callers are not able to reach us. But feel free to call 510-657-1170, 510-657-1170. And I was discussing, of course, about those two important situations, the cap gap, and also about the RFEs and notice of intent to deny, also based on the September 11 situation of the memo. So what happens in these cases is that a lot of people are finding themselves worried because we have not really started seeing denials without RFEs, but we are expecting it will come soon. So at this point, I was talking a little bit about this situation where a group of lawyers went to talk to the USCIS, and they mentioned that if it is just a simple error or misunderstanding, they won't just issue a denial. They'll probably send an RFE. Remember, they still have discretionary power to send an RFE. So let's hope things are going to make sense, because at this point, I'm kind of lost. What they are really kind of planning. So all those things are happening, and they're not stopping, and there's no way we can really figure out to what extent they're going to really kind of affect immigration law. And the truth is, more and more we are seeing people panicking and doing things that are going to hurt you. For example, jumping on a D1 CPT is not a great idea. Now, jumping onto a multiple same level education is also not a good option. So what do? That's a problem. There are not many options. So make sure that you're compliant. As for those people who are on student visas, if you have a violation, unfortunately, if you look at this memo, when it comes to unlawful presence, a violation would just happen. For example, let's say you didn't maintain your F1. I'm sorry. If you didn't maintain your F1 properly, and you basically don't realize it, but you continued going to school, and then suddenly they discover that, they will go back in time and count you from that day of violation of the F1 till now of unlawful presence. And what unlawful presence does, if you have an unlawful presence of more than 180 days, and if you have to go outside to get a stamping on any kind of visa, you won't be able to come back for 3 years. Let me give you an example here. Let's say you have an H1B, and not H1B, you have an F1, and based on your F1, you basically didn't maintain let's say an OPT. You violated the OPT rule. For example, the STEM extension, your employer was not E-Verify, etc. But nobody really paid attention to that, and you continued working. Let's say 1 year down the road, you're filing an H1B, and they found out you violated that. They will count all this time from the violation till now as unlawful presence. And that's where it gets very, very tricky, and why people are panicking on the unlawful presence. And the unlawful presence will become a problem. Number one, you cannot change status. Number two, you cannot really adjust status on a regular, normal I-140, for example. Only thing that can help, if in case you have a citizen spouse, of course, then things will change. But at the end of the day here, we are seeing a lot of things that are happening, and a lot of people are panicking. But But that doesn't mean cases are not getting approved. We just got a bunch of cases approved, etc., etc. So, Michael, I just wanted to check if we are able to get any calls right now, because we had some issues right now with the phone, it seems, and many people calling, we're not able to hear them. So I apologize for that. So bottom line now, I wanted to check also with some of the other things that we do as a law firm. One of them is basically getting we do debt settlement. Debt settlement is also something now very related, because many people are leaving and they don't know if they will want to keep their situation here, their money here, or they have a lot of credit card debts and they don't want to mess their credit that much, because you still will have issues with the credit. But you also don't they don't want to they're leaving and they won't be able to afford to pay the loan or things like that. So we can negotiate for you. We cannot help on student loans, but we can help on many other loans. So feel free to reach out to us and let us know if you need any help. One thing we also wanted to tell people, that if you have a debt and you basically, for example, a credit card debt, let's say you owe $10,000 or $100,000, and now you cannot afford to pay because you're losing your job, or you have to go back to India, or for other reasons, you can just give us a call. Let us negotiate for you and reduce that amount ultimately, that you can just pay and get it over. Because the problem is that if you keep a debt, ultimately you're going to get sued on it, and once you get this, you get sued, you end up by losing, etc. Then you will have to pay. And not only pay, they can garnish your paycheck, basically levy your bank account, or even put a lien on your property. So it is important that you negotiate this debt, get rid of them, and we can help you. You can call the office 510-742-5887. Let me go back a little bit to immigration, and let us talk a little bit about the present situation that we have right now on all the fronts. Number one, it seems like more and more there are perpetual attack on the H1B, L visa, etc., etc., and they are doing that. We are seeing cases which are filed properly, got everything in there, getting denied too. Luckily, we still have a higher portion of approval than denial, but definitely, with no RFEs, we might see worse denials coming. And if you look at the memo, who are they going to who are going? I think I have Raj on the line, right? Let me take Raj back. Hi. Hello.
Hello.
Yes.
Hello?
Hi.
Yeah, hi. Thank you for taking call. Actually, I got a question about the kind of the 180-day rule. So basically, my brother, he has a H1 renewal applied on April 6th, and it's now 180 days, and actually he's got an RFE. So because if RFE comes and he gets rejected, I'm just wondering, like, actually, does he have to leave by within 180 days, or like does he have time after 180 days is over and RFE gets rejected?
Okay, first of all, you have to basically kind of have a 994 valid pretty much. And then the I-94, that's a different story. The 180 days is not a grace period, okay? All the 180 days does is that you are forgiven if you have to, once you leave to get your stamping and come back, you don't get penalized, because once you reach more than 180 days, you will be blocked to enter the United States for 3 years. And if you have an unlawful presence of 365 days, it gets worse. So bottom line, the 180 days is not a grace period. You're not really allowed to work or even stay, but they kind of forgive you for that if you leave on time and try to come back. So that's pretty much the 180 days rule.
Yeah, but if he's not leaving, in a sense, like actually he doesn't know if H1B gets extended or not. That's why, suppose 180 days are over now by October 6th, then later, like say in 10-15 days, comes to know that he got rejected, H1B got rejected, then can he leave right away and then still be eligible to come back because the proceedings are not started to deport him or something like that?
Well, if he stays more than 180 days unlawfully, that means illegally, quote unquote, he won't be able to come back when he go. And the only way he can get back on a visa, unless, for example, marriage to a U.S. citizen, a U visa, and abuse cases, etc. The 180 days is not a rule of. Basically, the 100 days is not a grace period. All it does is just protects you to come back when you go for stamping. That's all.
But then I think when they apply for this H1B renewal after it has expired, they are taking for a long time to renew, take a decision or something. So then during that time, is it considered to be a legally present or illegal?
Okay. That's a different story. The 180 days counting starts when the case is denied, not when it is pending. When it is pending, it's a period of authorized stay. That means your brother can stay. There's no problem with that. However, there's another rule of 240 days. So he can continue working for 240 days, but once 240 days is passed, he cannot continue working. He can continue staying, but he cannot continue working. Those are two different things. The 180 days applies only when it gets denied. Then the unlawful presence starts. Okay.
So means it starts from the date of denial, or?
Yeah, it starts from the date of the denial.
But can they put the date of denial as the application, like renewal date, like say from April 6th, the previous H1B expired on April 6th, so they applied for renewal. Can INS deny and
technically no, because it would be kind of backdating stuff. So no, they cannot really do that. Okay, but they can put the date. Well, let's say for example they put a date of last week. By the time you receive the letter, 1 week has passed.
Okay.
So, good luck to you, Raj. And I don't know how much time we are left, Michael. So, if we have other callers, this is Shaprai. You'll have an ear. Hello. Okay. I don't think you have more callers, and I don't know if I have time also for more callers. But we are talking, of course, about immigration law. I talk a little bit about debt settlement, and we're also talking about what's going on with the cap gap. And I'm going to recap a little bit here. Cap gap and recap. I'm going to recap a little bit here, basically on what's happening out there on the cap gap. The cap gap is a way to protect the students who file for an H1B if the H1B is picked up to continue working until September 30th, until the H1B kicks in on October 1st. But what we have a problem right now, we have situations where many people have not gotten an answer on their H1Bs, and as such, what happens to them next? And they cannot continue working after September 30th. And one of the solutions that has been proposed is to sue the government under the Writ of Mandamus, and I spoke to about that earlier in the show. So it is an option on the table, but it's not something that you can really just check. So, ladies and gentlemen, I think we're almost done now. I think Amit is there, so I just wanted to say thank you for listening. We'll be back next week. I'm really sorry today. It's like with the phone calls and also the overwhelming situation. I apologize. So, anything I'm telling you today is my opinion. You should not act or refrain to act solely on the information provided. You should contact an attorney if you have any questions. Number to our office, 510-742-5887. I think Amit is there. Amit, are you there?
Hi, Shayas. How are you?
I'm doing well. I think, Amit, you have 7 or 8 minutes to go, so I'll let you finish. Thank you, Michael. Take care. Bye-bye.
Thank you, Shah, and Sat Shri Akal.